Welcome to this video series on the making of international in Korea. My name is Seokgu Lee, and I'm a professor of international law at Inha Law School, which is located in Incheon, Korea. Before getting into this first lecture, I would like to give you a brief introduction about myself. I'm a graduate of the Korea University, where I received my undergraduate law degree and then went on to receive Master of Law degrees from Korea University, the University of Minnesota, and New York University, and finally my doctorate from the Oxford University. I'm the general editor of the Encyclopedia of Public International Asia and co-editor-chief of the Asia Pacific Journal of Ocean and Policy and Asian Yearbook of International Law, and exec editor of the Korea Journal of International Comparative Law. This is the logo of the Encyclopedia of the Public International Asia. This encyclopedia is composed of the 3 volumes touch upon the Northeast Asia and Southeast Asia and Central and South Asia. Over 286 academics working on very specific issues of the international law and produced over 1 million words of the various headings to touch upon the very specific issues of the international law. And also, there are the 3 volumes of the productions of publication I want to share with you. The first, Asia Pacific Journal of the Ocean and Policy and Asian Yearbook of International Law, and Maritime Cooperation in East Asia. All those volumes working on the very specific issues of the international law in Asia, how international law intertwine in an area of the Asia. And also, there are the couple of the issues we're working on. The first, Encyclopedia of the Ocean and Policy in Asia Pacific, which will come out this year. And also, we're working on the 2 main publications which given to that the main sources of this lecture. The first is that the Korea Journal of International Law and Comparative Law. This is produced by the Korean Society International Law, and this year we produced the volume 10 and celebrates the centennial year of this volume. And the Korea Journal of International Comparative Law to produce the various corner of the issues we're working on, and it gives you that the brief understanding of how international law imply in Korea. And also the making international law in Korea, from colony to Asian power. The title of this book is coincidentally identical with this lecture, and it adopted from the various legal issues we're working on together to produce the how international law apply to Korea. As you can gather, my interest and focus has been on the topics of international law, and especially how international law has developed here in Korea, and how it applies to Korea in some of the important issues that face this country in the 21st century. As you probably know, the economic development in Korea has brought about tremendous changes to Korea. Formerly annexed by Korea in 1910, Korea was Japan's colony for 35 years until Japan's defeat in World War II in 1945. It emerged from the Japan's colonialism as a divided nation occupied by the communist forces in the north and the United States in the south. This division culminated in the Korean War from 1950 to 1953, which ravaged the peninsula and left Korea as one of the poorest countries in the world. However, recently Korea ranked as the 11th largest economy in terms of the GNP and is often lauded as one of the Asia's tiger and miracles of the economies. Korea has ascended to become a legitimate Asian power through rapid development during the latter half of the 20th century, from being a third world power at the end of the Korean War. The rise of Korea tracks neatly with advent globalization and the growing importance of international law in managing the increasing interactions between states themselves and open non-state entities such as the multilateral corporations and non-government organizations and international organizations such as the United Nations. Korea's rise has occurred in one of the most dynamic and dangerous parts of the world, which is in Northeast Asia, encompassing the People's Republic of China, North and South Korea, and Japan. This region has undoubtedly taken a greater global geopolitical and economic significance. It is under these conditions that international has taken on a greater role in Korea and its neighborhood. So, now we'll begin in the first week of the video, which is a description and explanations of the core principles and practices of international law, and discuss the primary sources of international law, like treaties and customary international law, along with the topics such as the statehood and state responsibility and sovereignty and jurisdiction. We are working on the various issues of the international law, but the term and the terminology we have to see this lecture should be governed the very definition of the terms which I talked to you. The first, the source of international law. Unlike domestic international law, the international has different sources. Where the law comes from in a different domestic legal system can be determined by the form of the government that a particular state has. In many states that have a constituted democracy, the constitution of a country is a source of the law along with the statute enacted by the legislature, which we say sometimes as court. In some countries, with a strong executive branch, administrative regulations issued by the executive, the agencies, we say, for example, administrative law is important sources of the rules. In countries that follow the common law, the judiciary makes the pronouncement of what the law is through the judicial decisions that are reflected in case law. Within a domestic legal system, the common characteristics found in relation to domestic sources of law, when viewed in light of the positivism, is the identification of the authority that makes the law along with the presence of the hierarchy between domestic law, along with the related issues which institutions can prescribe, adjudicate, and enforce the rules. As such, domestic legal system has a vertical orientations and origination of the legal authority. In contrast, because there is no formal legal authority of a state, such as a world government, the basis for international law is state consent. The state consent is a very important term to govern the international law, because this gives the international legal system a horizontal orientation of the rules that is created between sovereign equals. Accordingly, the source of international can be found from the lawmaking actions of the state themselves. While in domestic legal system, the law emanates from the sovereign and applied and enforced toward legal persons, in international legal system, the source of the rules is derived from the sovereign states, who are both the source and object of international law. The international law are the rules that govern the activities of the states between them. For the International Court of Justice, the main quarters are located in The Hague in the Netherlands, which is the principal legal organ of the United Nations. The law which it applies in settling disputes between states include international conventions, international custom, and general principles law recognized by the civilized nations pursuant to Article 38 of the Statute of the ICJ. Given that the consensual actions taken by states are the primary basis of the international law. The two principal sources of international law are international conventions and international customary law. International conventions or treaties are international legally enforceable agreements between states, while international custom or customary international law is made up of consistent state practice and opinion juris, which is the essence of the legal obligation. State action in the form of the treaty making and the state practice element of international custom confirm the sense that international law are product of sovereign will. As such, the source of international law have been largely explained within the context of the legal positivism, in that international law is created by the sovereign state to govern their own actions, as opposed to an early understanding that international law was derived from the sources apart from the states, such as the natural law. Thank you very much for your understanding with this. And as I emphasized, this one is that at the first lecture give you that the very important definition of the sources of international law, which you will apply to every case we're talking about this series of the video. So thank you very much. We're looking forward to seeing you next section. Thank you.